please. Now, Mr. Appellant, the court wishes to make a short statement before you start your appeal. You can sit down.
Thank you.
The board wishes to take this opportunity to commemorate and to celebrate the long service to this court and to its users of Robin Lloyds, who has recently died. Robin was admitted as a solicitor in 1973, and his long career as a Privy Council agent spanned the periods of office of no less than 5 of our registrars. Robin began his career in the law with Clifford Turner, which he joined straight from school. He spent about 10 years there before joining Philip Conway Thomas. He subsequently moved to Saunders & Co., where he became established as a regular user of the Privy Council, before moving to MA Law and then Axiom Stone, and he retired from practice last year. Robin acted mainly in appeals from the Caribbean and Mauritius, but he also undertook work from Hong Kong through the legal aid department there. His former colleagues estimated that he acted in over 75 Privy Council appeals in the course of his long career. To a British audience, perhaps the most famous case in which he acted was the dispute over the baronetcy of Pringle of Stichill in 2016. But he also appeared in constitutional cases which are landmarks in the jurisprudence of Caribbean countries and of Mauritius, including the famous case of Attorney General and Ramanup in 2006 about the award of damages for breaches of constitutional rights. Over the course of almost 4 decades as a Privy Council agent, Robin became one of the most well-known and most recognizable users of this court. Even now, his distinctive white hair can be seen in the picture of the court in action which greets visitors to the JCPC's website. Both the court and its users are beneficiaries of long-serving Privy Council agents like Robin, and we remember his life service with gratitude. We also send our sympathy to his widow Karen and to his family, some of whom are participating this morning on our live stream. Thank you very much.
Hearing the bill, Sassy Garcia against Arima Door Centre Holding Company.
Yes, Mr. Ramlan.
My Lords, I appear on behalf of the appellant. I've been informed that the respondent is unrepresented and wish to rely on their written submissions.
That's my understanding. They're here by their Privy Council agents, I think.
Yes.
And they wish us to rely on what they said in writing.
Yes.
But they're not proposing that any oral submissions be made to the court.
Yes. Correct.
So, you can continue.
Yes. So, my Lords, firstly, I would just take my Lords very briefly through the pleadings of the parties. And the purpose of that is to demonstrate that the parties were ad idem on the fact that the notice that the tenancy ended on the 30th of April 1996.
Well, it would certainly help us to look very early on at what the factual basis is on which we're to deal with the issues that arise on the appeal.
Yes. So, so if my Lords look at the amended claim form, the re-amended claim form, which is at 376, my Lords would see, and also the statement of case, which is in the supplemental bundle, page 4. My Lords would see that the case presented by the claimant is essentially that they were claiming possession on the basis of it being the landowner and having served several notices to quit, 3 to be exact, 2 in 1982 and then 1 in 1996. And if my Lords were to look at the re-amended defense paragraph 11,
Page
page 367.
367.
Yes.
Yes.
Yes. My lords will see at paragraph 11, what is averred there is that the contractual tenancy has never been terminated prior to the 1st January 1996. The effect of this, my lord, is that the respondent did not challenge, the appellant did not challenge the notice to quit on the 29th March 1996. That notice to quit is at page 268. So,
just give me that page again, please.
268.
Thank you.
And then, and in the reply, the defense to counterclaim at paragraph 4, that is at page 372, the respondent again confirms that the tenancy was terminated by either one of 3 notices to quit. Those are the 2 1982 notices and the 1996 notice.
Which paragraph are you looking at now?
Paragraph 4, my lord.
On page 373.
72.
It's 73 in ours.
Sorry. Yes. So what we say the effect of that is, my lords, is that the parties were ad idem on the fact that the tenancy came to an end on the 30th of April 1996, pursuant to the notice to quit, which I referred my lords to earlier. And at paragraph 11 of the appellant's case, my lords, we have succinctly set out key features of the evidence, in particular the main witness for the respondent, Mr. Evans Mondi, which demonstrates clearly that there was no acceptance of any relationship of landlord and tenant subsequent to the 30th of April 1996. Now, my lords would have seen that the issue of statutory tenancy seems to have arisen in the courts below. But it is our position that statutory tenancy ought not to have featured in this case at all, because it was not an issue in the respective case pleadings before the court. And to demonstrate this, if my lords look at the claimant's pleading, again the re-amended claim form at page 376, and the statement of case at page 3 of the supplemental bundle, my lords will see there's absolutely no averment of the appellant being a statutory tenant. So it was not part of the respondent's case. And then if we look at the appellant's pleading and the re-amended defense and counterclaim, at paragraph 10, that which is on page 367, the appellant there avers that on the 24th February 1982, the tenancy was registered. So the appellant has pleaded at paragraph 10 that the tenancy was registered. Now, in the respondent's response to that paragraph 10, which is to be found in their defense to counterclaim. At page 372, the claimant's response to that argument is that they have put the appellant basically to strict proof of that. So they have not accepted in their pleaded case that the tenancy was in fact registered. And of course, the witness statements would demonstrate that there was never any proof or no evidence put before the court of the tenancy being registered. Further to that, in the appellant's defense to counterclaim at paragraph 11, my lords will see that the appellant expressly renounces any claim to protection of the statutory tenancy. So it is a re-amendment, and my lords will see that part where the appellant was previously claiming that there is a statutory tenancy in force was now deleted.
The reference for that again, please.
367.
367 again, is it?
Yes, and that's paragraph 11.
Thank you very much.
So on that basis, my lord, in respect of the case that was before the court, we say there was no issue of statutory tenancy having arisen at all, and it ought not to have featured in the proceedings at all. Now, if my lords were to look at...
What's the impact of a statutory tenancy? What effect does it have? If there had been such a tendency, would the notice to acquit have been sufficient to bring it to an end?
No, my lord, which I would present as an alternative position, because the trial judge considered two alternative positions, one in which the tenancy ended and one in the event that the statutory tenancy subsisted after April 30th, 1996. Now, my lord, the Court of Appeal in Trinidad and Tobago Court of Appeal in Bikram Ramdial versus Trevor Kerry, tab 1 authorities, paragraph 18. At page 519, what it says in effect, what the Court of Appeal says, relying on English authority, what it says is that the Rent Restriction Act gives the tenant no more than a personal right to possession. That is a defense to a claim for possession. And then they go on to quote from Lord Justice Roma.
Sorry, where are you reading from?
That would be paragraph 18 in the authority, Bikram Ramdial versus Trevor Kerry.
Page 520.
And that's page 519.
It's 520 on our bundle, at least on mine.
Yes, great. Yes,
Yeah.
mine too. So,
Now, the significance of that is that the appellant did not, as I just pointed out to my lords, avail herself of that defense, of any defense of statutory tenancy, both in the High Court and also in the Magistrate Court, in which ejectment proceedings were commenced in 1996. And this can be seen in respect of the Magistrate Court. If my lords were to look at the transcript of proceedings, at page 185, line 26, where the witness, Evans Mundy, who represented the landowner in 1996, stated basically that the matter was in effect abandoned after 5 years or so, because it was repeatedly adjourned since the tenant never came to court. So, my lords would
Sorry,
say,
this is a transcript from the evidence at the trial, is it?
yes, yes. line 26, at page 185.
Just
This evidence is summarised in the judgment, I think, anyway, isn't it, the judge?
Yes, but I'm just demonstrating that in both, that the authorities have established that the statutory tenancy in effect is really a defense to a claim for possession, and which the appellant did not avail herself of in either the High Court or in the magisterial proceedings, the ejectment proceedings in 19.
the trial judge found at page 158, paragraph 58, that the original tenancy was converted into a statutory tenancy upon the death of the defendant's father, that's Mr. Hannay,
Yes,
on the 19th of February 1996.
yes,
And you accept that the notice of quit wouldn't bring the statutory tenancy to an end, is that right?
yes, it would have been brought, the notice to quit would have brought the tenancy to a statutory tenancy.
It would have brought, sorry, I misunderstood you.
Yes, yes.
Right. Yeah, okay.
But bear in mind, my lords, I've indicated that it is a finding, that the trial judge ought not to have made, because the issue of a statutory tenancy, whether it exists, whether it doesn't exist, whether it was terminated or not, was not before him on the pleaded case.
What difference does it make whether it was a statutory tenancy or a contractual tenancy if the notice to quit would bring both of them to an end? What difference does it make?
Well, the trial judge held the view that if there was a statutory tenancy in place, that would have come to an end in 2001 or 2002 when the defendant's mother died.
So, and was that because he thought the notice of quit wouldn't have brought the statutory tenancy to an end?
He considered alternative positions. So he did not make a specific finding of whether the notice of quit brought it to an end or not. He considered in the first instance, if the notice of quit was sufficient to bring it to an end, then this is the position. And then he considered if the notice of quit was insufficient to bring it to an end, then he gave his position on that. So he did not make a specific finding. He considered two alternative positions and concluded that in respect of either of those positions, the appellant did not satisfy the 16-year requirement. And, my lords, that the alternative positions are set out, firstly in paragraph 59, that's his first position, the primary position of the trial judge. And if my lords look at if my lords look at 59, it's very instrumental, because it is here that we submit the trial judge would have erred in his analysis, because if in his primary position, he says if the notice to quit was sufficient to determine the statutory tenancy, then the statutory tenancy would have come to an end by 30th April 1996. The right to re-enter would have accrued by the 1st May 1996. And here it is where we say that the learned judge fell into error. He says, unless as per provisions of section 9 of the Act, there was a later payment of rent, since the Act outlines that time shall start to run on the determination of the tenancy or when rent was last received, whichever shall happen last. And that is incorrect. That is not what the section says. The section says that time shall start to run at the end of at the determination of the first of the period of the tenancy, or when rent was last received, whichever shall last happen. And his alternative position is to be found at paragraph 64.
Page?
And that would be page 160.
160.
Yes.
Thank you.
Yes, and at paragraph 64, he says, even if even the statutory tenancy could not have been determined by the notice to quit, which is not a point raised by the defendant, then it must have come to an end upon the death of the defendant's mother. And therefore, he said the time would have started to count from the death of the defendant's mother, which was in 2002. And again, we say even in the alternative position, the learned judge fell into error.
Sorry.
So,
On the alternative position, the judge fell into error because in paragraph 64, he considered what would be the position if the notice to quit did not terminate the statutory tenancy. And he found that it would have come to an end in March 2002 when the defendant's mother died. And therefore, he found that that is when the time would have begun to run in respect of adverse possession, which surely would have led to the appellant not making 16 years, because from 2002 to 2012.
But you say we don't go there because there was no dispute to the efficacy of the notice to quit.
Yes, so the tenancy was ended. Yeah. So, in applying the facts that I've just pointed out to my lords to Section 9 of the Act, Section 9 of the Act clearly refers to and deals with a person who is in possession as a periodic tenant. And this is, if my lords look at authority, tab 3 on page 538. 538.
Thank you.
That's the judgment of Hende Puran versus Kenneth Rope, Court of Appeal, Trinidad and Tobago judgment, at paragraph 23. It states there what is the effect of Section 9. And states the section lays down a special rule for the running of time for periodic tenancies. So in effect, what Section 9 is, it's really a mechanism by which you calculate.
You always seem to be one page out from our bundle, so you need perhaps to adjust your references. That sentence you read comes on
537, my lord?
No. 539 of our bundle. The section lays down a special rule. Is that what you're referring to?
Yes, my lord.
Well, on my copy at least, it's 539.
Very well, my lord.
The top of the page.
Yes. So, this is, we say that the trial judge misapplied Section 9, because if the tenancy had come to an end on the 30th April 1996, then
at the time of the payment of, or the payment that was made on 23rd August 1996, at the time that payment was made, the appellant was no longer a tenant, or a periodic tenant for that matter, within the meaning of Section 9. And therefore, the trial judge ought not to have applied Section 9 to the facts of this case. In fact, my lords, at paragraph 5, well, it would be 540, sorry, page 540 in the same judgment of the Court of Appeal, the Hindi Puran judgment, the Court of Appeal dealt with what is the effect of a determination of the tenancy in the effect of Section 9, where you have a determination of the tenancy.
So in which paragraph are you now reading or going to? I'm on page 540.
My lord, I have it, it's paragraph 24.
24.
Yes. I have it as 530.
Reference to case of Williams and Jones?
Yes, correct. So, referring to Williams and Jones, the effect of the determination of a tenancy under a similar provision to Section 9 was to deem the tenancy at an end for the purpose of the Limitation Act. And then now...
What's your point on that? Sorry, I haven't followed it.
Yeah, the point, my lord, is that although the tenancy came to an end in 30th April 1996, the judge seemed to believe that when the payment was made in August 1996, that Section 9 still applied.
I understand that, but what's the point about Williams and Jones that you were referring to
Williams,
paragraph 24? What's that? What passage of that are you relying on?
Yeah, Williams and Jones held that the effect of the determination of the tenancy under a similar provision of Section 9 was to deem the tenancy at an end for the purposes of the Limitation Act.
Yes.
So therefore, following Williams and Jones, when the tenancy came to an end on the 30th April 1996, then time ought to have begun for the purposes of the Limitation Act.
I don't think it's. I don't see that. You may be right about your submission, but I don't see that Williams and Jones helps you, because that's simply saying that where Section 9 does apply, let's say in a case where there's no notice to quit served, and it's simply that the tenant stops paying rent.
Yes.
Then Section 9 does apply to tell you when the tenancy ends for this purpose, and that is when time begins to run. I think that's what Williams and Jones is saying.
I'm guided, my lords. Now, I will just take my lords, deal with the issue of how the Court of Appeal reconciled the ending of the tenancy with the application of Section 9. And my lords, we have set out, that has been set out at paragraphs 13 of the written reasons of the Court of Appeal.
Page?
Just a moment. It's at page 123, which maybe 124 in the Lord's bundle.
Well, if it's paragraph 13 you're after, 1, 2, 3 is spot on.
Yep.
Yes. So in paragraph 13, this is how the Court of Appeal apply in section 9 to the fact that the tenancy had come to an end, or at least the fact that a notice of quit was served on the appellant. It says in any event, it says firstly, the appellant remained an occupier in possession of the premises, even though a notice of quit was served on her, which brought it in the realm of section 9. And it is my submissions, my lord, that that the fact of the appellant remaining an occupier in possession cannot, after the end of a tenancy, cannot bring the matter within the realm of section 9. In fact, it is remaining in possession, which allows the time to start running in her favor. And secondly, it says in any event, the appellant, with the benefit of legal advice, was initially continuing to assert after the claim had been filed that a contractual tenancy subsisted. And he refers to paragraphs 5 and 6 of the appellant's affidavit. And we say that again, my lord, is of no, is not sufficient reason to bring the matter within the realm of section 9, because the appellant asserting in an affidavit, which, by the way, is not part of a pleaded case in these proceedings, cannot bring her within the realm of section 9.
It would do if the tenancy continued. But you say the tenancy had come to an end at the end of April.
Yes, the tenancy had come to an end at the end of April. But they're not saying that the tenancy continued after April. What they're saying is that is what the appellant asserted.
It's in fact evidence that the tenant was intending to stay in possession was intending to possess the land, which is part of what you need to show for adverse possession.
Yes.
That they were there with an intention to possess.
Yes. So we are saying that in any event, the appellant saying in an affidavit that it was a statutory tenancy, it cannot give her or ascribe to her a status that she did not have in law, because whether or not she's a statutory tenant is a matter of law. So if she goes on affidavit and deposes, I am a statutory tenant, that does not make her a statutory tenant. It is the facts of her possession and the circumstances of her possession which will determine whether or not, as a matter of law, she is a statutory tenant. So insofar as the Court of Appeal attempted to reconcile section 9 with the fact that a notice of quit ended the tenancy on 30th April 1996, we say that the Court of Appeal fell into error in that regard.
Where does one find paragraphs 5 and 6 of the appellant's affidavit? It's referred to paragraph 13.
It is at Exhibit EN 10, page 280.
Thank you very much.
So,
May we just have a quick look at those?
yes.
Well, in paragraph 6, she says that the contractual tenancy has never been terminated. And that's actually what's said in paragraph 11 of the re-amended defence and counterclaim. So it's also in her pleading. Well, what it there says rather oddly is the contractual tenancy has never been terminated prior to the 1st of January 1996.
Yes.
I'm on.
Yes. So in other words, she's saying the contractual tenancy was never terminated prior to 96, which the effect of is she is not challenging the notice to quit, the later one. Now, my lords, I just want to just explain how this affidavit came about. The claim in the High Court was initially filed by a summary proceeding, a claim form and affidavit. Yep. And after this affidavit was filed, the court because there were disputes of fact, the court directed pleadings to be filed. So pleadings were subsequently filed, and those matters form no part of the pleaded case before the courts.
And the affidavit is what, the 25th of June 2012?
Yes. And the pleadings came after that. So there was a re-amended claim form and then a statement of case on the 13th of July. I will now consider, my lords, and...
So she was just wrong when she said the contractual tenancy has never been terminated.
Yes, and we say those are matters of law in any event. The alternative position, my lord, is had there, and that is the alternative position considered by the trial judge at paragraph 64. That is, had there been a statutory tenancy subsisting subsequent to the 30th of April 1996, what would have been the position? Now, my lords, and we say the position is the time continues to run, or time does not stop running because there's a statutory tenancy in place, in force, and that is, if my lords were to look at the Bikram Ramdale judgment, which I referred to earlier at paragraph 18.
I'm sorry, the page number of that, sorry?
At page 150.
Okay.
Sorry. At page 519.
Where are we looking at that, sorry?
At paragraph 18, where reference is being made to the Moses versus Lavrov case.
You mean on page 520 again?
Yes. And my lord, I would see this case is authority for the proposition that statutory tenancy does not stop the time from running for the purposes of the Limitation Act. And further to that, the trial judge himself accepted that fact. If my lords were to look at his the written reasons of the trial judge, paragraph 38, my lords will find that at page 150. lords will see, the judge referred to the case of Jessamine Investment Company and SWAT, 1976 3 All England Report 521, for the proposition that the statutory tenancy would not have affected the running of time. Are my lords with me?
So how do you say, under the mechanism of the Act, how does the Act identify when the right accrued to recover the land? How do you identify in the Act when time began to run? Which provision? You say time began to run when the tenancy ended.
Yes, sir.
Which provision of the Act tells us that? Not Section 9, you say, because that doesn't apply. So which section does apply?
That's a moment, Lord. I believe it is 3. I just confirming that.
Maybe.
Paragraph 3. Because once the tenancy was terminated.
Well, that paragraph 3 tells you that time begins to run when the right accrues.
Yes.
But which provision tells you when the right accrues? You say nothing? You just have to
Yes, well, because once,
work it out?
yes, because once the tenancy came to an end, the appellant had no status. It was simply in possession as a trespasser, so to speak. So Section 3 would be applicable in those circumstances.
Well, does any part of Section 4 tell you? And if so, which part?
Do you think Section 6 might?
Maybe 6.
Maybe 6, is it?
Well, Briggs is suggesting,
Well, I'm
or floating, Section 6.
suggestion will put it all together too forcibly.
Yes.
Time when the state shall have become an estate or interest in possession by the determination of any estate or estates in respect of which such land shall have been held or the profits have been received notwithstanding the person claiming such land.
So the landlord holds an interest in reversion until the tenancy ends,
Yes.
and then has an interest in possession.
Yes.
Right?
I mean, is that the sort of reversionary interest which Section 6 is about? And we often talk about a landlord's
most
interest
of the
in reversion or
authorities-
tenancy, but I wonder if what's the date of this act?
1846.
I wonder in 1846 that would have been understood to be what it meant.
I think most of the authorities that deal with Section 6 deal with written long leases, where you have adverse during a long lease, but the time doesn't run against the landlord
Until the end of the lease.
until the lease has come to an end.
Yeah.
So I've seen, but I've never seen 6 being applied to a oral periodic tenancy.
Another way of looking at it could be under Section 4A. On the basis that dispossession occurs when somebody's in possession without the consent of the owner,
Yes, my lord.
according to
Yes, my lord, I would
House
accept
of
that.
Lords authority.
I mean, 9 appears that the enabling words of Section 9, the first
Yes.
6.5 lines, appear to apply to all unwritten periodic tenancies.
Yes. But we say that the wording of that suggests that those deal with cases where there is an existing tenancy. So, if you have a tenancy, it hasn't ended, but the tenant stopped paying rent,
Yeah.
you apply 9 because it says where any person shall be in possession as a tenant from year to year or other period. So a precondition of the application of 9 is the tenant has to be, the person has to be in possession as a tenant, periodic tenant.
So you say 9 is a sort of way of working out when time starts to run, when there isn't a notice to quit.
When there isn't a notice to quit, you have an existing tenancy. So it says either you take the end of the first period of tenancy, or last time rent was paid, whichever shall
The
happen.
last time rent was received.
Yes.
And you said it would be a bit odd if it worked in some other way, because the rent in respect of a period before the tenancy actually came to an end might be paid many, many months later.
Yes.
And in the meantime, the
Yeah, so the
person
rent,
is now in possession of the property
right.
and asserting an interest against that of the landlord.
Yeah, so the rent was paid in August, but it was paid not for the month of August. It was paid in respect of March and April at the time the tenancy was subsisting. So in effect, it was payment of a debt of rent owed.
Yeah.
It wasn't payment acknowledging the existence of a tenancy.
If the landlord had accepted rent for August, then one could say that a new tenancy had come into existence at that point.
Correct.
But it was simply receiving the outstanding debt that was owed from when the tenancy did exist.
That is correct. Now, my Lord, I want to also, and what I'm saying further, is that even if you had the statutory tenancy existing post 30th April 1996, then Section 9 still does not apply to the statutory tenancy. And the authority for that proposition, my lord, is the Privy Council case of Herman Ramdas and Marilyn Bahonanan. I don't know if it's before, my lords, it was sent belatedly by email.
Yes, we got it separately.
But
Yes,
I was
we
advised
have.
that it was forwarded to the board.
2009.
Yes, so 2009,
Yes, we do have it, thank you.
yes. And if my lords look at paragraph 22, from paragraphs 22 to 24, my lords would see there were two Court of Appeal judgments, Court of Appeal of Trinidad and Tobago judgments, for which counsel set out to overturn, and for which the board eventually agreed with. And it says, in those Court of Appeal judgment, the judges, the Isles and Warner, they treated the expression, this is at paragraph 22, he treated the expression tenant in the Land Tenants Security of Tenure Act as having a restricted and specific meaning. Following some English authorities, the statutory tenant has no interest in land, but merely a personal right to remain in occupation, a statutory license, so to speak.
Well, that's good enough for time not to start running, isn't it? A license. No. If you're there under a license, you're entitled to be there, and you're not a trespasser.
No, but the effect of this is that when you became a statutory tenant, what you have in effect is a sort of license, a defense, and as I mentioned in the earlier authority, the Bikram Ramdial, it is simply a defense to a claim for possession. So you are not to be considered a periodic tenant once you are a statutory tenant.
But this judgment isn't about the running of time or adverse possession at all, is it?
Yes, but it is what it is about is the effect of what.
But you have a defence to a right to an action for possession. Is that what you're saying? If you're a statutory tenant?
Yes.
And that's good enough to stop
yes.
time running under the Real Property Act. Your point has to be it's not a defence that was raised here.
Yes.
Yes.
Otherwise, you've had it, I think.
It's not a defense that was raised, as I indicated, but also the case, the authorities I referred to, which is the Moses versus Longgrove, and also that the judge referred to, which I referred to, also indicated those authorities state that the statutory tenancy, notwithstanding, it creates a statutory restriction or potential from possession. It doesn't stop time from running.
Yeah.
And the trial judge accepted that.
And that's based on the Jessamine case?
Yes.
And is that case in the bundle?
No, the judge referred to it. It's not in the bundle. and also the Moses versus Longgrove case, which was referred to in Bikram Ramdial.
And you bring the statutory tenancy to an end by what in circumstances such as this? If there were a statutory tenancy.
By a notice to quit.
Is that under some provision, some statutory provision, that provides how you bring a statutory tenancy to an end?
Because we're going around in a circle, because you say it came to an end at the end of April.
Yes.
There may have been a statutory tenancy thereafter, in which case what brought the statutory tenancy to an end? Or what would have brought it to an end?
The notice to quit, if there was one in existence, the notice to quit in April 1996 brought it to an end.
So there couldn't have been a statutory tenancy after April 1996?
No,
Why not?
because the notice to quit terminated it as a matter of law.
Terminated the contractual tenancy.
Yes.
Why isn't there a statutory tenancy?
I thought, well, the judge was saying would have come to an end when the tenant died, which was in 2002.
Yes.
No, what
That's when the statutory tenancy ended.
well, the Act provides several ways in which you can bring a statutory tenancy to an end.
Is that in the bundle? No, I take it it's not.
No, because, my lords, as I indicated earlier, part of my submissions is that statutory tenancy never featured or to have featured in this case, because these arguments now as to whether the tenancy lawfully came to an end or not was not made in the High Court because they were not part of the pleaded cases before the court.
With respect, that is a different point. It may be your best point, but at the moment...
You're making other points, don't you need to substantiate them?
Yeah. If this was a statutory tenancy, the position at the moment seems to be that it carried on until the death of the person in possession.
So you also have the point that it doesn't count according to that authority for the purpose of the Act.
And that requires us to look at Jessamine, which we haven't got.
No.
Well, my lords would see in the same very judgment, it was held by the Court of Appeal and accepted by the board that the notice to quit served on the predecessor of Mr. Ramdas did in fact bring the tenancy to an end.
Where brought the contractual tenancy to an end, yes.
The trouble is, I suspect that a statutory tenancy conjures up a different structure in the minds of someone used to the English or UK Rent Acts.
Yes.
And it may conjure up in the minds of someone looking at the similarly purposed but no doubt differently worded legislation here.
Yes.
What is the legislation?
The legislation is the Rent Restriction Act. But there are two. There's the Rent Restriction Act and there's the Rent Restriction Dwelling Homes Act. The Rent Restriction Dwelling Homes Act was placed in this bundle upon request of counsel for the respondent.
But you say that's the wrong act because this isn't a dwelling house?
Well, it is in the dwelling house, it is in the Rent Restriction Act that you will find all the different ways that you can bring the statutory tenancy to an end.
But none of this is referred to by the Court of Appeal, is it? The Court of Appeal have approached this purely on the basis of
Section 9.
of Section 9.
And in fact, the only issue that permission to appeal was granted on was the interpretation of Section 9 and its application to the facts.
Yes.
So none of these other issues are actually before the board at all.
Yes.
And your submission on Section 9 is it's absolutely straightforward. The tenancy came to an end at the end of April, and that's the end of it.
Yes.
The fact the rent was paid many months later in respect of that period up to the end of April is neither here nor there.
Yes. But I'm saying, in addition to that even if there was a statutory tenancy in place, it would not fall within the definition of a periodic tenancy for the purposes of Section 9, because a statutory tenancy is simply, as the authorities say.
It might well not,
Yeah.
because it's not an interest in land.
Yes.
But that doesn't mean it didn't postpone the running of time.
Yeah.
I mean, it's one thing to see whether it's a beast contemplated by Section 9,
Yeah.
but Section 9 long precedes the Rent Restriction Acts.
Yeah,
And one is not going to look in Section 9 to find any answer to the problem of whether a statutory tenancy prevents the running of time, because it's a creature that probably only came into existence about 100 years later, or at least many years later.
Is the respondent relying on the statutory tenancy in their submissions?
They couldn't.
I don't think they are.
No, and it was.
I think you're making the case more difficult for yourself rather than by your submissions at the moment.
Deleted from their pleading by amendment.
But the grant of leave to appeal was the issue. That's at page 72. The statutory interpretation issue and its application to the facts as found by the Trinidad and Tobago courts. So I suppose one has to actually find what the facts are.
Well, I must say I didn't read the leave as being whether Section 9 applies to the facts of the case. I read it as what does Section 9 mean and how does it apply to these facts?
Yeah.
I mean, if it was intended to raise the issue whether Section 9 applies to a statutory tenancy, I'm sure it would have said so.
Yes.
It doesn't say that because it wasn't part of anybody's case.
No.
The statutory
And the
tenancy.
respondent hasn't made any submissions on the point, and if you need to answer.
So I think you may be getting yourself into more difficult waters than you need.
Guided. And
The only point taken by the respondent is the Section 9 point that you've addressed us on.
yes. Now, the other issue, so just the other issue is that even if the appellant could be considered to be a periodic tenant, as at the time of the payment of rent on the 23rd August 1996, then we say, in respect of that, is that payment ought to relate back to March and April 1996. So it cannot be considered. So even if you satisfy all the conditions for Section 9, and you say, which says, first of the end of the first period, or last payment of rent, whichever shall happen last. When you construe in the last payment, when rent shall have last been received, which is the word then used, you have to apply that payment to March and April, and not August 1996.
I mean, it's a difficult argument on the wording of the section.
Yes.
It is, but
It doesn't mean received on your
It does
case.
say, and or at the last time when any rent payable in respect of the tenancy shall have been received. I mean, that would really rewrite the section, wouldn't it?
but if my lords look at the Court of Appeal judgment in Hindi Puran, just a moment.
So the Court of Appeal is in this case or another case?
No, in the Puran case,
Oh, sorry.
which is page 538 or thereabouts. That's where
Yes,
you took it.
if my lords look at page 539,
Yeah.
so the Court of Appeal applying Section 9 stated, in this case, the last payment of rent was made on February 4th, 1985. And it was made for the period June 1st, 1984 to May 31st, 1985. So in effect, you had sort of an advance payment here. And what the Court of Appeal said is, for the purposes of the Limitation Act, time would therefore start to run from June the 1st, 1985. So if my lords know, I believe they are referred to a Privy Council judgment.
But, I mean, this doesn't help you, though, does it? Because here, the payment of rent was made before the end of the periodic tenancy. Whereas in the present case, the rent is paid after the end of the periodic tenancy.
But what it does is, if we apply the strict wording of the Act, it says when rent shall have last been received.
Correct.
And rent shall last been received on the February 4th, 1985.
Well, no, because it was the later of the receipt of rent or the end of the periodic tenancy.
Well,
so the tenancy ended, that's how on the 31st of May.
What I am submitting is what Section 9 says, is the later of two things.
And the first
being
the
end of the first period of the tenancy.
Yes.
And the second being when rent shall last been received. And if my lords looked, the rent, if you take a strict literal approach, February 4th, 1985 would have been the date rent shall last have been received. But in this case, the Court of Appeal said they looked at the rent being applied to a period.
You're saying it means
to a period.
the last period for which rent is received.
And if one looks, and I am saying that that is consistent with what would have been the purpose of the section, because the payment of rent, the reason why it stops time from running is because it is in essence an acknowledgement of title. But if one pays rent, as in this case, in August 1996, but you paying for March and April, you are not acknowledging that the landlord as your landlord in August 1996. You are acknowledging that he was your landlord in March and April, and therefore I have money for you and I'm paying you. So on a policy basis as well, the section, we are saying it has to be interpreted as the Court of Appeal did here. You have to look at what was the period the payment was for, and not the actual date of the payment. So we say that in any...
to find precisely what the facts were of
Yes.
the case, to see whether that might have been the first period.
Well, it says, I did see something.
But I mean, the reasoning in paragraph 23 is pretty clear, isn't it? And makes perfect sense.
You pay your rent in advance. The landlord has got no right to dispossess you until the period expires. And so Section 9 is a deeming provision. It can, you can look behind it at the real facts.
But none of that assists the respondent in this appeal, in your submission, because the rent was paid in respect of a period before the tenancy came to an end.
Correct. which argument was rejected by both the High Court and the Court of Appeal, who applied the literal, what is the date the last payment was made, and they applied that.
I mean, it's a possible explanation of Section 9 that where you have an unwritten periodic tenancy, its periodicity is usually established as a matter of evidence by periods when rent is paid.
Yes.
Not some different period in respect of which rent is paid, it just rent is paid.
Yes.
That establishes what the periodicity of the tenancy is.
Yes.
But none of that, in a sense, it's a sort of evidential, it's a solution to an evidential conundrum, which is unnecessary if there's a notice to quit.
Yes.
And in this case, it was a monthly tenancy, the first period.
Yes, it was those are undisputed facts. It was a monthly tenancy commencing in 1971. My lords,
You're just about up to your time.
yes,
And I think you've covered the ground, unless there's anything else you want to add.
my lord, I just, because the respondent hasn't appeared, I wanted to deal frontally with issues which were raised in the submission.
Fair enough.
And there seemed to be just one minor issue, which I think shouldn't trouble my lords too much, but I'll still address it. The respondents seem to have been hinging their case on a purported admission of payment of rent in 2000.
Where are you now?
Paragraph 33 of the reasons of the trial judge.
33.
Yes, at page 148.
Yeah.
Yeah, so you would see that the claimant case was mounted on the fact that rent had been unpaid since the year 2000 by the defendant's own admission. And we say that really at this, we say that that is not something, or that is not an argument that the respondent was entitled to rely on, because it was never, the respondent made no positive averment as to when rent was last paid.
Well, you've got the judge's finding as to the last time rent was paid, and so none of this is
96,
relevant.
yeah. So the judge did not accept this in any event, but it featured very prominently in the respondent's submission, so I just...
Well, it doesn't feature in their submissions for this appeal, does it?
I believe it is there.
It does it?
Yes. But, my lord, in any event, when one looks, if you look at paragraph 24 of the reasons of the trial judge, page 146, my lords would see the comparison of the statements made. One in the affidavit, the first being in the affidavit, and the second being in the witness statement.
Beg your pardon, which paragraph are you in now?
Paragraph 24 of the written reasons, page 146.
Yes, thank you.
Yes.
Yeah. And, my lord, we say that in any event, that does not constitute an unequivocal admission that rent was in fact...
Well, you're going into things that are just making things too complicated.
Yes.
We've got an agreed fact that the last time rent was paid was on the 23rd of August. We don't need to consider alternative factual arguments that weren't accepted by the trial judge.
I'm guided, my lord. In those circumstances, my lord, those are my respectful submissions, unless
Well,
my
thank you
lord
very
wishes
much.
to hear any.
Thank you very much indeed.
Thank you, my lord.
Well, that's the end of the oral part of the hearing. We're grateful to counsel for his submissions and
Thank you.
indeed for the work done on the written submissions on both sides. The board will take time to consider their judgment.